Okay. Let us continue our discussion on the revised Corporation Code of the Philippines. Okay, last meeting, okay, this is part 3. Okay, our last topic is yung distinction between de facto corporation, okay, de jure, and the corporation by estoppel. Okay, now let us now proceed, okay, for the effect of non-use of corporate charter and continuous in operation. Okay, kasi under the corporation law, okay, required kasi yung corporation na mag-formally organize at mag-commence ng business operation within a period of 2 years. Okay, yan dati sa Batas Pambansa bilang 68. Okay, however, under Republic Act 11232, okay, ginawa na siyang 5 years. Okay, take note under BP 68, yung effect class ng non-use of corporate term for a period of 2 years, sabi dyan, the corporate powers cease and the corporation shall be deemed dissolved. It seems that the corporation is automatically dissolved. Pero by the way, before that, meron tayo class na sec, okay, opinion, na hindi raw siya automatic. Okay? Kasi bibigyan ng chance yung corporation to explain. Okay, why is it that they fail to formally organize and commence business operation within a period of 2 years? Okay, by the way, that is just a sec opinion. In fact, pag tinanong yan before doon sa CPA board exam, based on BP 68, ang treatment is automatically dissolved. Kasi merong provision doon sa BP 68 na hindi raw mag-apply yung provision ng section na yan. Okay, kapag okay, yung non-operation daw, okay, or failure to formally organize, okay, is not due to the fault of the corporation. Okay, pero it seems that in RA 11232, okay, in-adjust siya ng 5 years. Pero dito clear, okay, kapag hindi kayo nag-formally organize at nag-commence ng business operation within a period of 2 years, then the certificate of incorporation shall be deemed revoked. Tingnan mo ha, as of the day following the end of the 5-year period. Kaya on the following day, after end of the 5th year, automatic dissolve ka. Kaya clear tayo dito, dissolve siya automatic. Okay, ngayon kung halimbawa, yung corporation ay nag-formally organize at nag-commence ng business operation, pero naging continuously inoperative sila for a period of 5 years. Under BP 68, ground dyan for what? Revocation or suspension, okay, ng certificate of incorporation. Sa Republic Act 11232, okay, 5 years din. Pero hindi siya revoke. Hindi siya ground for revocation. But rather, okay, after due notice and hearing daw, okay, kasi yung due notice and hearing is part of the due process yan. It will place the corporation under delinquent status lang. Ngayon, bibigyan ngayon yung corporation ng 2 years, okay, para mag-comply. Okay, at okay, magkaroon ng operation. Ngayon, pag nag-lapse yung 2 years na yan, yan yung ground ngayon for the revocation ng certificate of incorporation. Kaya before, sa BP 68, ang tinatandaan nyo is 2-5. Okay, bali 2 years, kailangan mag-formally organize at mag-commence ng business operation. Tapos, kung okay, formally organize at nag-commence ng business operation, pero naging continuous inoperative for 5 years, then ground dyan for the revocation or suspension ng okay, certificate of incorporation. Pero dito sa RA 11232, ang tatandaan nyo ay 552. Bali, 5 years for formal organization and commencement ng business operation. Tapos 5 years naman, okay, pag nagkaroon ng continuous in operation. At yung 2 years, okay, para okay, matanggal yung kanyang pagiging delinquent status. Ngayon, pag binasa mo yung provision mismo sa law, okay, sabi dyan, if a corporation does not formally organize and commence its business within 5 years from the date of incorporation, its certificate of incorporation shall be deemed revoked. Tandaan nyo as of the day following the end of the 5 years. Kaya following the end of the 5 years, automatic dissolve siya. Automatic revoke ang inyong certificate of incorporation. Okay? However, if a corporation has commenced its business but subsequently becomes inoperative for a period of 5 years. Ito meron kayong formal organization at commencement ng business operation pero naging continuous inoperative kayo for 5 years, 5 consecutive years. The commission may, after due notice and hearing, place the corporation under delinquent status. Ngayon kapag halimbawa, dineclared ka na as delinquent status, bibigyan ka ng 2 years ngayon. Okay, para mag-resume ng operation at i-comply all the requirement set forth by the commission. Otherwise, failure to comply that requirement, then okay, ground na siya for the revocation ng certificate of incorporation. Now, the commission thou shall give reasonable notice to and coordinate with the appropriate regulatory agency prior to the suspension or revocation of the certificate of incorporation of companies under special regulatory jurisdiction. Kaya yung mga corporation, okay, governed under special laws, like banks, insurance companies, di ba? Under rules ng, okay, banking yan, General Banking Acts, okay? Now, yung isa naman is Insurance Code of the Philippines. Okay? Now, bibigyan daw sila, magbibigay ang commission daw ng reasonable notice, okay, para makipag-coordinate doon sa mga appropriate regulatory agency like Bangko Sentral, okay, or Insurance Commission prior to the suspension or revocation of the certificate of incorporation of those companies. Okay, now let us proceed sa okay, election of director trustee. Now, general rule plus, sino ba ang mag-e-elect okay, sa director trustee? Siyempre, of course, the stockholder. That's why the rule is that any stockholder may nominate director trustee. Okay? As long as those nominated possess all the qualification and none of the disqualification. Pero tingnan nyo, nakalagay sa batas, except founder shares with exclusive right to vote and be voted. Bakit? Kasi di ba kung nare-recall nyo, ang founder shares, pwede silang bigyan kasi ng exclusive right to vote and be voted for a limited period of 5 years. Kaya kung meron silang exclusive right to vote and be voted, edi sila lang ang pwedeng mag-nominate. Okay? For a limited period of 5 years. Kasi sila lang ang merong exclusive right to vote and be voted. Pero kung wala namang founder shares, the general rule is that any stockholder, okay, or members naman, in case of a non-stock corporation, okay, may nominate any director trustee. As long as those nominated are those nominated possess all the qualification and none of the disqualifications. Okay, now pwede kayo magkaroon class ng okay, voting either in person or pwedeng through a representative authorized to act by written proxy. To simplify, ibig sabihin pwede kang bumoto either in person or through a proxy. Pero ito may dinagdag ngayon sa RA 11232. Pag authorized daw ng bylaws or majority ng BOD, okay, pwedeng bumoto ang stockholders or members, okay, yung tinatawag na voting by absentia through remote communication, okay, or voting by absentia. Okay, pero ibig sabihin, the general rule is that para makaboto yung mga stockholder, okay, ng remote communication or voting by absentia, dapat authorized ng bylaws or by majority ng board of directors. Pero may exception. Pag ito raw ay corporation imbued with public interest, okay, kahit walang provision authorizing sa bylaws, okay, then pwede ang voting by absentia. Okay, o yung tinatawag na remote communication. Now, question. Ilan plus ang quorum ng board of directors? Okay? Wait lang. Okay, ilan class ang quorum ng board of director? Sabi dito, unless the articles of incorporation or the bylaws provides for a greater majority. A majority of the director trustee as is stated in the article of incorporation shall constitute a quorum to transact corporate business, and every decision reached by at least majority of the director trustee constituting a quorum. Okay, now kung babasahin yung maigi ang provision ng batas, kung nakalagay dyan, unless the article of incorporation or bylaws provide for greater majority. Kaya ibig sabihin, pwede nating dagdagan, pero hindi natin pwedeng bawasan. That's why, halimbawa, there are 15 directors. The quorum of 15 is 8. Can the article of incorporation or the bylaws provides for the quorum of 9? The answer is yes. How about 7? The answer is no. Kasi ang sabi ng batas, di ba, unless the article of incorporation or the bylaw provides for greater majority. Kaya pwede siyang dagdagan, hindi nyo pwedeng bawasan. Pero pag kinompared mo yan sa cooperative law, okay, ang nakalagay lang dun, unless the bylaw provide otherwise. Kaya ibig sabihin, pwedeng dagdagan, pwedeng bawasan kung ang nakalagay sa bylaws ng cooperative. Pero sa corporation law, hindi pwedeng bawasan kasi ang nakalagay nga, unless the article of incorporation or the bylaw provides for a greater majority. Okay, now question. If there are 15 directors, of course the quorum is 8. If there are 9 directors present, you need 5 votes in order to have a valid act of the corporation. But if there are 15 directors, ang umattend ng meeting is only 7. Kahit bumoto yung 7, invalid act siya ng corporation because there is no valid quorum. Wala silang quorum to do business. Another question. There are 15 directors. Patay ang 3. Ang question, ilan ang quorum? Answer is 8 pa din. Kasi hindi ka naman nakabase sa buhay. Nakabase ka sa number of director fixed in the article of incorporation. Kaya nga, titignan mo ha, as is stated in the articles of incorporation. Sabi mo, sandali lang sir. If there are 15 directors, patay po sir ang 10. And therefore, ang remaining directors is only 5. Question. Okay, ilan ang quorum? The answer, of course, is 8 pa din. Sabi mo, paano mangyari yun, sir? Patay na yung 10. Okay, 5 lang ang natitira. In that case, wala kayong valid quorum. In that case, kailangan nyong mag-call ng special stockholders meeting to fill up the vacancy in the board. Okay? Kasi otherwise, lahat ng act na gagawin ng directors invalid for lack of a valid quorum. Pero by the way, there is a provision now in Republic Act 11232 creating what we call an emergency board. Okay? Pero may requirement for the creation of the emergency board. Kasi obvious naman ba't ka mag-create ng emergency board? Okay, kasi una, wala na kayong valid quorum. Kasi ba't ka mag-create ng emergency board if there is a valid quorum of the board? And second, dapat merong emergency. Kaya nga emergency board Ibig sabihin, kailangan may immediate act na gawin, of course, yung corporation. At another requirement is that kailangan, magkokos ito ng irreparable injury sa corporation. Kapag hindi nagkaroon ng immediate act, yung board. Kaya lumalabas, that is a new provision under Republic Act 11232. Okay? Now, kaya tandaan nyo ha, hindi tayo nakabase sa buhay. Nakabase tayo sa number of director, fixed in the article of incorporation. Pero take note, ito laging natatanong sa board exam before. Okay, pagdating daw class sa election of officers. Okay? Ayan ha. Election of officer. Okay, kailangan nyo, okay, ng majority, okay, ng all members of the board. That's why if there are 15 directors, you need 8 votes in order to have a valid election of corporate officers. Okay? O yan ang exception ha. Pero syempre kung halimbawa ordinary act lang siya ng corporation, syempre kailangan ko lang ng majority ng board of director present with a valid quorum. Except of course, syempre kung halimbawa mga fundamental changes ng corporation yan, ay dapat kailangan ko ng majority ng board of directors. Now, by the way, class, ingatan niyo yung mga voting requirement. Kasi may mga tinatanong, for instance, na halimbawa, ang tinanong sa inyo, ilan ang voting requirements for a valid corporate act? O simple lang ang sagot. That is majority ng board of director present with a valid quorum. Pero kung halimbawa, fundamental changes na yan, ay majority ng board of directors na siya. Okay, kaya kung merong 15, dapat may 8 votes na siya. Okay, on another, election of corporate officers. Question, ilan class ang number of directors? Let us compare. Kasi alam mo naman, magandang gawa ng tanong, okay, yung changes from BP 68 to RA 11232. Okay, at yan ay malamang commonly asked question sa board exam. Siyempre kung halimbawa, okay, sa BP 68 kasi, pag stock corporation is not less than 5 but not more than 15. Pero pag non-stock, pwede siyang more than 15. Kung nakalagay yan sa Article 11 Corporation or the bylaws. Kaya nakalagay nga sa Section 92, the number of trustees shall be fixed in the Article 11 Corporation or bylaws, which may or may not be more than 15. Kaya pwede siyang may not be more than 15. Kaya pwede siyang i-increase. Pero under Republic Act 11232, mapapansin mo, wala na siyang nakalagay na minimum of 5. Nakalagay lang dyan, number of director which shall not be more than 15. Kaya baka tanungin mo, sir, ilan po ang lumalabas na minimum number of director? Since walang nilagay na minimum, okay, it should be understood that this is the minimum of 2. Okay? Bakit minimum of 2? Kasi kung 1 siya, it refers to an OPC. Remember, an OPC as a special corporation siya. Ngayon, kung non-stock corporation naman, okay, the number of trustees shall be fixed in the articles of incorporation or bylaws which may or may not be more than 15. Kaya technically nga sabi ko sa inyo, basta stock, maximum 15. Okay? Pagdating sa non-stock, pwede siyang more than 15 trustees. Now, ilan class ang terms of office ng director? 1 year. Okay, until their successor is elected and qualified. Now, emphasize ko lang na elected and qualified. Kasi may tinatawag tayong holdover period. Kasi possible na ikaw ay na-elect, pero hindi ka pala qualified. Kasi hindi ka pala owner ng at least 1 share of stock. Pag binasa mo yung Republic Act 1123, walang nakalagay na at least owner ng at least 1 share of stock, pero may nakalagay na related provision that the moment you dispose your at least 1 share of stock, you cease to be a director. Kaya it seems that required pa rin na owner ka ng at least 1 share of stock. Kung hindi ka owner ng at least 1 share of stock, it means hindi ka qualified. Kaya sinong director dito? Ikaw pa din. Kasi may holdover period ka. Ilan naman ang terms of office ng trustees ng non-stock? 3 years. Okay, not more than 3 years. Kung halimbawa ito ay non-stock edu corporation, then dumalabas 5. Kaya tandaan nyo is 1, 3, 5. 1 for stock, 3 for non-stock, and 5 years for non-stock educational corporation. Pero sa cooperative, 2 years. Kaya tingnan nyo ha, i-compare mo yan sa cooperative. 2 years ang terms of office ng director of cooperative. Ano ba ang qualification ng director? Siyempre, owner of at least 1 share of stock, and you need to possess all the qualifications and none of the disqualification. Dati kasi may nakalagay pang majority must be resident of the Philippines. Pag binasa mo yung provision ng code, wala ka nang makitang nakalagay na majority must be resident of the Philippines. Kaya yun ang qualification lang, at least one shall be stopped, possess all the qualification, and none of the disqualifications. Pero take note, ito bagong provision to. Okay, in consonance with Security Regulation Code. Corporation vested with public interest shall have independent directors constituting at least 20% of such board. Kaya lumalabas yung mga corporation imbued with public interest, kailangan nyo ng independent directors. At kailangan ng at least 20% ng total number of directors. That's why if there are 15 directors, the minimum is 3. Kailangan ko ng at least 3 independent director. If there are 10, you need 2. If there are 5 directors, you need 1. Okay, kailangan ko ng at least 1 independent director. Pero nag-a-apply yan sa mga corporation only imbued with public interest. Now, let us compare the disqualification of director, trustees, or officer. BP 68 versus Republic Act 11232. Pag binasa mo yung BP 68, nakalagay lang dyan na disqualification, dapat hindi ka pa convicted ng offense wherein the penalty imposed by law is more than 6 years imprisonment. And second, dapat hindi ka nakakommit ng violation ng corporation code raw nitong BP 68 within 5 years prior to the date of election or appointment. Okay, election, syempre sa board or officers. Applicable din kasi yan sa officers. Okay, appointment of officers. Okay, now, ngayon, ibig sabihin kung magkakaroon ka ng reference sa revised penal code, pag ang penalty imposed by law is presyon mayor, reclusion temporal, reclusion perpetua, saka death, abay hindi ka na qualified para mag-run as director. Kasi lahat yan ay more than 6 years imprisonment. Pero pag ang penalty imposed by the revised penal code is arresto minor, arresto mayor, presyon correctional, qualified ka pa rin to run as director. Kasi hindi naman siya more than 6 years imprisonment. Okay? Now, pero dito sa Republic Act 11232, sabi dyan, if within 5 years prior to the election or appointment as such, dito may period na eh. Ibig sabihin, ito yung date ng election. Okay? Yung date ng election, dapat within 5 years prior to the date of election, hindi ka pa raw na-convict by final judgment number 1 of an offense punishable by imprisonment for a period exceeding 6 years. Okay? Baka kasi mamaya na-convict ka pala dyan, nakapatay ka, kung homicide dyan, the penalty is normal reclusion temporal to reclusion perpetua. More than 6 years imprisonment dyan. Okay, or for violation of this code, for violating Republic Act number 8799, otherwise known as the Security Regulation Code or the SRC. Found administratively liable for any offense involving fraudulent act, and C, by a foreign court or equivalent foreign regulatory authority for act violation or misconduct similar to those enumerated in paragraph A and B. Okay? Now, other disqualification may impose by the Commission, as primary regulatory agency, or the Philippine Competition Commission. Kaya ibig sabihin, pwedeng mag-provide ng additional disqualification ang SEC, or pwedeng primary regulatory agency like Bangko Sentral, with respect to banks, or Insurance Commission with respect to insurance company, or the Philippine Competition Commission. For the promotion of goods corporate governance daw, or a sanction in its administrative proceeding. Now, ano ba klase ang powers ng Board of Director? Okay, ang powers daw ng Board of Director, sila yung may power mag-exercise ng corporate powers na makikita nyo sa Section 36 ng BP 68 dati na Section 35 ngayon under Republic Act 11232. Conduct all business and they can control all properties of the corporation. Kasi tandaan nyo ang rule class, ang pwede lang mag-bind as a rule sa corporation is the board. At hindi lang basta board of directors na individual. They need to act as a body. And therefore, dapat meron silang valid quorum. Ngayon, let us proceed now sa definition of an independent director. Actually, itong Section 22 na definition ng independent director, it was lifted from rules on corporate governance issued by the SEC. In Memorandum Circular number 6-2009. As is, kung anong definition ng independent director, on the rules on corporate governance, under Memorandum Circular number 6-2009, nilift lang siya. Kopya siya verbatim. Independent director daw is a person who, apart from shareholdings and fees received from the corporation, is independent of management. Independent daw siya ng management. Kaya normally ito yung mga directors na nagko-qualified, na binibigyan sila ng at least 1 share lang para mag-qualified for director. Outsider. Para magkaroon ng independent view. Para hindi makontrol ng mga nandun lang sa loob ng directors na corporation. From any business or other relationship which could reasonably perceive to materially interfere with the exercise of independent judgment in carrying out the responsibility as a director. Ngayon, under the rules on corporate governance, for publicly listed company, kapag ikaw ay may holding, na more than 2% of the outstanding capital stock, that is a ground for temporary disqualification. Kasi hindi ka na mako-consider as independent daw nun. Now, kaya dapat yung holdings mo maliit lang. Kasi para ma-considered ka pa rin as independent. Free ka from any material interference from outsider. Ibig sabihin doon sa mga existing director. Now, sino ba nag-e-elect ng independent director? Actually, same as director lang din yan. Of course, ang nag-e-elect sa directors is the stockholder. Present or entitled to vote in absentia during election of director. Kasi di ba sabi ko, yung stockholder, pwede naman bumoto yan either in person or through a proxy, written proxy, or kung authorized nga ng bylaws or majority ng board of director, pwede yung tinatawag na voting by absentia or through a remote communication. Now, independent directors now shall be subject to rules and regulations governing their qualifications, disqualifications, voting requirements, duration of terms and term limit, maximum number of board membership, and other requirements that the Commission will prescribe to strengthen their independence and align with international best practices. Now, by the way, paki-familiarize to. Ito yung mga corporation imbued with public interest or vested with public interest, and therefore kailangan nyo ng independent director as provided under RA 11232. Syempre kung yan ay covered ng Section 17.2 of Republic Act 8799 or otherwise known as the Security Regulation Code. Namely, those securities are registered with the Commission. Corporation listed with exchange. Kaya kung listed yan sa stock exchange, kailangan ng independent director. Tapos ito yung public company. Actually, yan ang definition ng public company. With asset of at least 50 million and having 200 or more holders of shares each holding at least 100 shares of class of its equities shares. Pero by the way ha, pag binasa mo yung rules on corporate governance, okay, and the implementing rules issued by the SEC, okay, on the rules on tender offer under RA 8799, ang nakalagay na dun, asset of exceeding 50 million. Conflict, di ba? Kasi ang nakalagay sa batas, okay, doon sa Section 19 of RA 8799 is at least 50 million. Pero doon sa implementing rules, naging exceed 50 million. But of course, basic rules is that kung may conflict man between law and okay, implementing rules, the law will prevail over the implementing rules. Kaya ito, okay, at least 50 million. Another yung mga bangko syempre. Bank and quasi-banks, non-stock saving and loan association, pawn shop, corporation engaged in money service business, pre-need, trust and insurance companies, and other financial intermediaries. Actually, yung mga naka-enumerate dyan ay under supervision of the Bangko Sentral. And of course, other corporations engaged now in business vested with public interest similar to the above as may be determined by the Commission. Okay, kasi ito insurance company, hindi naman governed ng Bangko Sentral. Pero normally, okay, nakakakuha sila ng fund coming from the public. Kaya yan, mga imbued with public interest, kaya kailangan muna, okay, kailangan nila ng independent director. Now, what are the relevant factors that which are germane to the objective and purpose of requiring the election of independent director? 1, minority ownership. Type of financial product, securities issued or offered to investors, public interest involved in the nature of business operations, and other analogous factors. Okay, yan yung mga factor na i-consider daw natin in requiring the election of an independent director. Okay. Now, let us proceed now sa qualification and disqualification of corporate officers. Okay, doon sa Batas Pambansa bilang 68, saka RA 11232 parehas. Okay, pag president, you must be a director. And to become a director, you must be an owner of at least 1 share of stock. Secretary, parehas din, both resident and citizen of the Philippines. Pero sa BP68 sa treasurer, ang nakalagay lang doon, a treasurer may or may not be a director. Kaya technically para siyang walang qualification. Pero under SEC opinion before, bago ka maging corporate treasurer, kailangan muna na ikaw ay resident of the Philippines. Because ang opinion ng SEC dyan, since you are a treasurer at may custody of fund ka ng corporation, you must be residing in the Philippines. And under Republic Act 11232, the opinion of SEC was incorporated. Kaya lumalabas ngayon, nakalagay na sa RA 11232, kaya kailangan resident of the Philippines ka. Dati kasi, walang basis under the law. Galing lang sa SEC opinion. Ngayon, may dinagdag na required corporate officer under RA 11232. Ito yung tinatawag na compliance officer. Pero kailangan lang ng compliance officer pag mga corporation imbued with public interest. Sa disqualification na diniscuss ko kanina, sa director or trustee, equally applicable yan sa corporate officer. Kaya ito yung bago, di ba? Sabi natin, if within 5 years prior to the election or appointment as such, the person wants, letter A, yun nga, na-convict ka by final judgment. Number 1, an offense punishable by imprisonment for period exceeding 6 years. Kaya sabi ko sa inyo, pag ang penalty imposed by the revised penal code is arresto minor, arresto mayor, prison, okay, correctional, okay, hindi yan more than 6 years. Kasi pag arresto minor, 1 to 30 days lang. Okay, arresto mayor is 31 days to 6 months. Prison correctional is 6 months and 1 day to 6 years. Pero once na yan ay prison mayor na, reclusion temporal o reclusion perpetua, lahat yan more than 6 years imprisonment. Kasi ang prison mayor is 6 years and 1 day to 12 years. Okay, pag reclusion temporal is 12 years and 1 day to 20 years, And reclusion perpetua is 20 years and 1 day to up to 40 years. Okay? Kaya more than 6 years imprisonment na siya. Hindi ka na qualified to run as a director. Another is na violate yung corporation code raw. Okay, pero tandaan nyo, may nakalagay na dyan limit ngayon ha, kasi dapat within 5 years prior to the election. Pag kinompare mo kasi dati, ito lang yung merong period. Okay? Nakakommit ka ng violation ng corporation code within 5 years prior to the date of election. Pero dito dati, convicted ka by final judgment, batas ng imprisonment more than 6 years, hindi ka qualified to run as director. Okay, another yun nga, violation ng SRC. Another is found administratively liable for any offense involving fraudulent act. Okay, by a foreign court or equivalent foreign regulatory authority for act, violation, or misconduct similar to those enumerated in paragraph A and B. Para lumalabas yung paragraph C, same nung A and B yan, pero nag-rendered ng judgment kasi dito, foreign court or foreign regulatory authority, like kung may SEC sa kanila. Okay, na nag-administer, okay, or governing agency with respect to corporation. Pwede ba ang concurrent position? Similar class sa Batas Pambansa bilang 68, walang nabago rito. Bawal lang dalawa, President, Secretary, saka President, Treasurer. Okay, ang rule is all other concurrent position allowed. Okay? Now, ulitin ko ha, ang nakalagay lang na corporate officers sa corporation law sa BP 68 dati, President, Secretary, Treasurer, and such other officers fixed in the bylaws. Ngayon, dito naman sa RA 11232, President, Secretary, Treasurer, and other officers din fixed in the bylaws or article of incorporation. Kaya ibig sabihin, ang rule is that kung hindi ka naman nakafix sa bylaws or sa article, ang rule is that hindi ka corporate officer. Sabi mo, ano ka, sir? Malamang isa ka lang empleyado. Now, importante ba yan? Yes, kasi pag tinanggal ka, lumalabas, may employer-employee relationship, then you can file an illegal dismissal before the labor arbiter, before the NLRC. At mag-a-apply labor code. Pero kung hindi ka naman class empleyado, kasi corporate officer ka, edi may tinatawag na intra-corporate controversy. And that is within the jurisdiction of the RTC. Okay, tinanggal na sa SEC. Okay, through Republic Act 8799. Kasi dati nasa ano yan nasa Security and Exchange Commission pursuant to PD 902-8. Pero through the enactment of RA 8799, okay, intra-corporate controversy is now transferred to a regular court. Now, ngayon, meron isang SEC opinion. By the way, SEC opinion lang. Okay, pwede ka bang maging chairman and vice chairman daw? According to SEC is no. Okay, why? Kasi, ano bang function ng vice? Normally, when the chairman is absent. Kaso buhaya ka sa posisyon. Kaya hindi siya allowed. Kung i-apply ko ba yung analogy, para lumalabas, hindi rin pwede ang president and vice president. Okay? But that is just a SEC opinion. Okay? Pero, okay, kung babasahin mo yung provision of law, nakalagay lang dyan, president, secretary, and president, treasurer. Kaya secretary, treasurer allowed, or pwede rin president, CEO, okay, or CO. Pwede kayong maggawa ng another office. Okay? Kaya president, CEO is allowed. Now, wag lang kayong gumawa ng other term na ang nature niya, baka treasurer din. Okay? Kaya lumalabas, lumalabas bawal yun. Okay, now let us proceed now sa removal of director trustee. Now, under BP 68, a corporate director trustee may be removed by at least 2/3 of the outstanding capital stock. Kaya based on BP 68, ang pwedeng mag-remove sa corporate officer, corporate director trustee is the stockholder. Pero under RA 11232 may dinagdag dito. Wala ka makikitang ganyang similar provision under BP 68, which is by the commission. Pwedeng mag-act ang commission either motu proprio or through a verified petition filed by a third person. Kaya pwedeng motu proprio, ibig sabihin pag sinabing motu proprio, at the commission own instance. Kahit walang nagfa-file. O kaya through a verified petition. Okay? Kasi pag na-determine kunwari na yung board of director for isang member ng board is disqualified pala, then pwede siyang i-remove as a director. Ngayon, ilan ang voting requirement? Ulitin ko, pag stock corporation, 2/3 ng OS, pero pag non-stock ay 2/3 ng members entitled to vote. Okay, pero dapat gawin yan either sa regular meeting or pwedeng special meeting. Pero called for the purpose. Tandaan nyo, pag may binanggit na called for the purpose, dapat nakalagay dun sa notice of meeting. One of the specific agenda is for the removal of corporate director trustee. Kasi baka mamaya ang nilagay nyo sa special meeting, kunwari mag-a-amend lang kayo ng article. Bigla nyong isisingit removal of corporate directors pala. Hindi pwede yun. Mga traidor kayo. Okay? Kailangan ilagay yan sa notice of meeting. Kaya nga called for the purpose. Kailangan ng previous notice, syempre, to stockholders or members of the corporation the intention to propose such removal at the meeting. At take note that the removal of corporate director trustee can be with or without just and lawful cause. Except that, okay, if that is a director representing minority stockholders, in that case, they can be removed only upon just and lawful cause. Kasi tandaan nyo, di ba, pagdating sa election of director, pag stock corporation, we are using the cumulative voting. Pag cumulative, kung meron akong 1,000 shares and there are 10 directors, 1,000 times 10, I have a total of 10,000 votes. Pag cumulative voting, I can concentrate the entire 10,000 votes to one director because the purpose of cumulative voting is to give chance to the minority stockholder to have representative in the board of directors. Kasi pwede nilang i-pull lahat ng kanilang votes at i-concentrate sa one director lang para magkaroon sila ng representative sa BOD. Okay, kaya hindi sila pwedeng tanggalin kung walang just and lawful cause. Okay? Ngayon, tandaan nyo ha, meron akong gustong i-emphasize. Merong question before sa bar exam. Halimbawa, si A for instance is a general manager. Okay? And under the corporate bylaws, the following are the corporate officers: President, okay, Secretary, Treasurer, CEO, okay, COO, General Managers, and others. At nakalagay doon, class, na ang corporate officers can be removed by vote of majority of the board. Later on, the board of directors of that corporation execute a board resolution removing A as general manager. However, A questioned the legality of his removal because according to him, he cannot be removed by majority of the board because pursuant to the law, okay, which is BP 68 before, when it was asked in the bar exam, okay, he can be removed only by vote of at least 2/3 of the outstanding capital stock. Now, the question is that, is the contention of A tenable? Of course, the answer is the contention of A is not tenable because the provision under Section 28 of BP 68 apply only to a corporate director or trustee. Pero since tinatanggal siya as a corporate officer, ang mag-a-apply is the provision in the corporate bylaws. Kasi tandaan nyo, kung ikaw ay director o trustee, i-apply mo yung provision sa law. Eh kaso walang nakalagay sa corporation law regarding removal of corporate officers. That's why ang masusunod yung provision under the bylaws. In fact, even there is no provision in the bylaws, a corporate officers can be removed by vote of the board of directors. Because the one who appoint the corporate officers is the board. And the power to appoint includes the power to remove. Now, kaya tingnan nyo may sa problem ha. Kung nire-remove ka as corporate director or trustee or as a corporate officer. Kasi kung director trustee, sundan mo ang provision sa corporation law. Pero kung ikaw ay nire-remove as officers, then sundan mo ang corporate bylaws. Ngayon, sino ba ang pwedeng mag-call ng special meeting for removal of corporate director trustee? Mapapansin mo ha, ang pwede lang mag-call dito ng special meeting for removal ng director trustee, number 1 is the corporate secretary upon order of the president. Pero syempre may instances na what if yung secretary ayaw mag-call? Okay? O kaya walang secretary. Kasi kung tatanggalin kunwari is as director is the president, of course the president will not order his secretary to call a special meeting for his removal. That's why in that case, pwede rin class mag-call ng special meeting upon written demand raw ng stockholders representing or holding at least majority of the outstanding capital stock or majority of the members entitled to vote. Kaya sabi yan, if there is no secretary or the secretary despite demand fails or refuse to call the special meeting or to give notice thereof, the stockholder or member of the corporation signing the demand may call for the meeting by directly addressing the stockholder or members. Now, notice of time and place of such meeting as well as the intention to propose such removal must be given by publication or by written notice prescribed in this code. Ngayon, ito yung pangalawa. Kasi di ba sabi ko sa BP 68 ang nakalagay lang ay removal ng corporate director or trustee through vote ng at least 2/3 of the outstanding capital stock. Pero ito dinagdag ito sa Republic Act 11-232 na pwedeng i-remove ang director through the order of the commission. At ang sabi dyan, the commission shall motu proprio. Pag sinabing motu proprio class it means at the commission own instance. Pwedeng mag-act ang commission at his own instance kahit walang nagfa-file or upon verified complaint. Siyempre kailangan ng due process kaya after due notice and hearing. Okay, pwedeng magkaroon ng order for the removal of director trustee. Okay, because of the disqualification arose or discovered subsequent to an election. Sabi dyan, the removal of disqualified director shall be without prejudice to the other sanction. Kaya pwedeng mag-impose ng sanction ang SEC dito. That the commission may impose on the board of director trustee with knowledge daw of the disqualification failed to remove such director trustee. Kasi kung halimbawa, alam ng other director trustee disqualified pala yan, ayaw nila mag-act. Kaya pwedeng mag-impose ang commission ng sanction. Okay? Now, sa report of election, tingnan nyo to ha. Pag halimbawa na-elect na class ng stockholder ang board, tapos si board naman nag-appoint na ng corporate officer. Similar sa Batas Pambansa bilang 68, may requirement doon na kailangan i-report within 30 days daw. Okay, yung election ng director trustee officer, okay, ang magre-report niyan secretary or any other officer ng corporation. Isasubmit sa SEC dito yung names, nationality, shareholdings, and residence address. Okay, of director, trustee, and officers elected. Okay, ngayon, ito yung changes. Okay, ang magre-report na secretary or director, trustee, or officer ng corporation. Dati kasi, ganito. Pag halimbawa daw kasi yung director, trustee, officer ay namatay, nag-resign, or otherwise cease to hold office. Now, ang magre-report niyan, pwedeng yung secretary, or pwedeng director, trustee, or officer of the corporation himself. Pero kung death yan syempre,
Ako na namang mag-report yung director, patay nga siya eh. Kaya lumalabas, okay, pwedeng yung secretary o kaya yung kanyang legal heirs. Okay, ngayon, kailan dapat i-report yan? O ito yung changes, pakitandaan to, baka biglang itanong ng examiner. Dati kasi sa Batas Pambansa bilang 68, pag nalaman class na patay na yung director, trustee or officer or nag-resign or otherwise sold office, kailangan i-report siya immediately. Pero walang period. But under RA 11232, abay naglagay na ng period. Dapat within 7 days daw from the knowledge thereof, dapat i-report sa SEC. Okay, yung death. Okay, resignation o kaya secession from office ng director, trustee, or officer. And the form of report must be in writing. Hindi siya pwedeng oral. Okay, ngayon, ganito yan. Okay, di ba, pag halimbawa na kayo ay formally na organized na, okay, ano ba yung ibig sabihin ng formal organization? Magkakaroon dito ng election of directors and appointment of officers. Di ang gagawin dito class ng stockholder, syempre, kailangan nila mag-elect ng board of director. Ang problema, during the stockholders meeting, pucha walang quorum. Eh ang sabi ng Batas Pambansa bilang 68 dati, okay, pwedeng isuspend ng stockholder ang meeting from day to day but not sine die. Hindi pwedeng indefinite. Kaya kung halimbawa ngayon wala tayong quorum ng stockholder, pwede natin i-suspend o next week or next month. Pero hindi pwedeng indefinite suspension. Okay, ngayon may requirement ngayon. Di halimbawa, nagkaroon tayo ng meeting of stockholder. Eh putya walang quorum ng stockholder. Eh di magsususpend ka ng meeting from day to day. Pero bawal lang ang sinidiya. Dati yun sa BP68. Ngayon hindi. Pag nagkaroon ng non-holding of election, ilalagay nyo, magre-report kayo sa commission dito, iligay-lagay nyo yung reason bakit walang election na nangyari. Tapos magkakaroon kayo ng setting of new date of election, pero not later than 60 days from the scheduled date. Okay? Ngayon kung halimbawa, dumating for instance yung new date of election, wala pa rin quorum. Kung sino lang yung present na stockholder dun, yan na yung magiging basis for the quorum of the stockholder. Kasi ang rule dapat, di ba, majority ng outstanding capital stock. Okay. By the way, break muna kayo. Gagawa na lang ako ng separate video. Okay, for the after the report of election. Okay, break muna kayo.